has a very rich jurisprudence in elevating the directive policies of state governments to the level of a human right, more or less, by giving those policy statements a purposive approach. Nigeria too has this one in its own chapter 2 of the Constitution. However, rather than just fold your hands and say that no, these ones are not justiciable, there are a lot of things that we can learn from the Indian courts. And of course, in a series of cases, the Indian courts have had to say that the environment is important, though the right to, though irrespective of what is in the directive principles of state policy, we have to let these things come up, because there is no way a person could enjoy the rights, the fundamental human rights, if the environment is not clean. In fact, in India, it has been suggested that there could be a special court, environmental court, and it was one of those things that I was happy listening to at the plenary this session. And those environmental courts, you need to have lawyers and judges too that will man it, so that it will really be something that will lead to speedy dispensation of matters before the court. So in moving forward, we suggest that some steps to be taken to remedy the messy situation. One, the Nigerian courts are to key into the activism of the Dutch court, as in the Gender Foundation case. And then B, that Nigeria will also do well to key into the major decisions arrived at during the Paris Conference of 2015. C, the country will do well to key into the judicial decisions of Indian courts by elevating rights by elevating right to a clean and healthy environment as a major component of the right to life and dignity of human person. And of course, that one also has been taken care of by the D, because the C and D goes together. E is suggesting that there should be special training for judges and court officials and court divisions that handle this class of matters. We should appreciate the salient issues involved, quick dispensation of suits, not on the altar of justice, but to ensure that justice is not unnecessarily delayed. Then we have in the country a bill pending before the National Assembly that has been there for over 6 years now, and the National Assembly seems not to be in a hurry at all to discuss it. That is the Petroleum Industry Bill. This bill has its attempts to solve some of this problem, if it will not just be in paper alone, if it will be given the necessary arm and feet that it desires. G is that there is a West African gas project which has been domesticated, which has been enacted, and this is something through which the country supplies natural gas to the whole of West African belt. So if you can make money by supplying natural gas to the whole of West African belt, Republic of Benin, Togo, Ghana, and on, then why waste it? So, I mean, that's something that the government will look at into. Domestic and industrial importance and uses of natural gas should be looked into. And of course, which I would say is very key, good governance to be encouraged and sustained in the country. In the absence of good governance, all other things go to nothing. Because however good the laws you may have, if we don't have a good government that is going to ensure that things are done properly, then forget it. So good governance is important. It is one thing to have the law, it is another thing to have a government that will ensure that things are done the way it should be done. J has been taken care of by C and D, which is the right to life, right to dignity of human persons. They don't have any meaning in the absence of a clean environment, and this is necessary for the enjoyment of the right. K is that any oil company that has refused to comply with the environmental regulations, the government has the right to refuse to. The government could, one, revoke its oil exploration license, oil prospecting license, or oil mining license, or well, the government may refuse to grant any additional license to such an oil company. And the next one is that we have passed recently in the country the Freedom of Information Act. and I was so happy when she was mentioning a similar thing in China just before we commenced. This one could be used by anybody, either an NGO, an individual, to compel oil companies to disclose periodically the level of compliance with extant laws which prohibit gas flaring. And the Freedom of Information Act has also stated specific days within which the person must respond. So if you have a request, you must respond within specific days. Failure to respond within specific days means that such a person from whom the information is being required will be deemed to have committed an offense under the law. M is that public interest litigation should be embraced in a holistic manner. If individuals are not willing to take action on gas flaring, then public interest litigation could be embraced in a holistic manner by some non-governmental organization, so that it won't just be an individual thing, but it will be something for the collective interest of all. And last but not the least is that the courts are empowered to use the Fundamental Rights Enforcement Procedure rules under the Constitution of the Federal Republic of Nigeria. There is an amendment to that rule, to the Fundamental Enforcement Procedure rules, made by the Honorable Chief Justice of Nigeria, and he has given arm and teeth and power to all courts now that yes, anytime there is any issue that borders on rights, that borders on public interest, the court should take it up and not allow itself to be bogged down by the old technicalities, which were making things very, very difficult for people. And it's at any stage of action it could be done. So this is something that is really, really very important. And finally, on conclusion, we say that the courts have a sacred duty to uphold the law, especially in this area. Failure on the part of the courts to do the needful will spell doom for humanity. The courts should be more purposive and judicially active in this area. In appropriate cases, the spirit and the letters of the relevant statutes should be upheld. Frivolous excuses and unnecessary limiting factors should be downplayed. All stakeholders in the administration of justice have a unique role to play in the enthronement of sustainable development of the Nigerian society. The National Assembly to give the Petroleum Industry Bill accelerated hearing and consideration, and more NGOs to be, more non-governmental organizations to be proactive, like the Gender Foundation in the Netherlands. Thank you.
Thank you, Any comments or questions for Idowu? Thank you for that interesting. Start here, then over there.
Okay. My questions will be, you say that to some extent that the court asking for like legal standing of people discourage them to go to the court to solve the problem. I mean, is that quote unquote normal for the court to ask for your legal standing? I mean, is there any reasons why people in Nigeria prefer to go to personal rather than communal way when they go to the court? Is there any class action for the loss of possible also there?
Okay, fine. Well, there's nothing wrong in the courts asking to let people to ask for the local standing for any litigant that is coming before the court. If the courts have failed to ask for the interest of a person, then the courts will be bombarded with all sorts of frivolous cases. Yeah. So it is really okay. But we are saying that because of the level of enlightenment, a lot of people will go to the wrong courts, or a lot of people will think that actions should be filed on their behalf, only to find out that yes, they don't have the local standing. So it is not wrong. It is not. But a balance should be maintained. That's the point we are trying to make here. Otherwise, the court will have all sorts of useless cases passed before it, and the court won't have enough time to attend to really good cases. Now, about class actions, and that's the last point we made there, that yes, more non-governmental organizations should be more active, and they should have learned a lot from what happened in Netherlands last year. So I really feel to the point, yes, we have to maintain that.
Can you give your background to and introduce yourself, and then
I'm Damilola Olawi, and thank you for the detailed presentation. I teach environmental law at Tafe Babalola University in Nigeria. And I was really interested in learning more about some of the transferable norms from Norway that you think can help Nigeria. As you very well know, the current government has set up a task force to clean up the Niger Delta, and I'm on that committee. And we are always very keen to know what are the key lessons that you think we can learn from Norway. Because someone, I think a Norwegian lawyer, was sort of criticizing Norway yesterday, saying that even though Norway has signed the Paris Agreement, they are issuing more oil licenses. So, you know, and since your research is sort of saying there are some key norms that can guide our committee, we would love to know.
Okay, thank you very much. Norway has one of the best platforms or policies in the world for oil producing, amongst oil producing countries.